So much again, Jackie, and thank you to the Grand Rapids Chamber for the opportunity to speak with you this morning. I am going to share my screen. Just a moment. Let me make sure that everyone can see that. Does it look good to you, Jackie? Okay, great. So I want to first of all commend each of you for joining us this morning because this is a really important topic, one that I think there will be a fair amount of publicity around in the coming months. And so I think it is really smart of each of you to get out ahead of it, get some information, and really feel prepared for whatever might be coming as we anticipate this new rule. So I am going to start by talking about the Fair Labor Standards Act exempt status, because we really can't understand this new proposed rule unless we understand the context in which it's arising. So we're going to spend a few moments talking about this statute and exemptions from this statute's overtime rule. Then we're going to talk about the current rule that is in place. We'll talk a little bit about why the Department of Labor has proposed these changes. Then we'll talk about what will be changing. And then I want to be sure and leave you with some really practical steps that you can take to prepare your workplace ahead of these changes. So let's go ahead and dive in and talk about the Fair Labor Standards Act. This is a federal law. It is the primary federal wage and hour law in the United States. It is enforced by the U.S. Department of Labor, sometimes called the DOL, and the DOL has broad investigative authority. So sometimes the DOL will investigate just because of a random audit. Sometimes they will investigate as a result of a complaint or a concern that has been voiced to them by an employee. But really, either way, when they show up in your workplace, they get access to a lot. And so we want to make sure that we have our ducks in a row, that we are compliant. So if we are ever faced with the DOL audit, we know that we are compliant and that we won't be facing any penalties. Separate from the DOL's audit authority, plaintiffs can also sue under the Fair Labor Standards Act. So a former employee or a current employee could sue in a wage and hour lawsuit and could recover any unpaid wages, an additional equal amount in liquidated damages, and then they can also get their attorney's fees and costs, which is why these types of lawsuits are often really attractive to certain types of attorneys to bring, because you can get your attorney's fees recovered through them. Okay, so that's the Fair Labor Standards Act. The Fair Labor Standards Act is where we find our federal minimum wage and where we find our overtime law. So that rule that if you work more than 40 hours in any given work week, you have to pay time and a half for hours over 40. That rule comes from the Fair Labor Standards Act. Now, the FLSA, that's our shorthand for the Fair Labor Standards Act, the FLSA allows employers to exempt certain employees from both the minimum wage requirement and the overtime pay requirement, okay? And this is the exemption. It's this part of the statute that has some changes coming to it. So that's kind of where we find these changes in the broad context of this law. Now, it's important to remember that employers have the burden of demonstrating that an exemption is appropriate. So if the Department of Labor or a judge were to ever be evaluating, hey, is this person really exempt from overtime? Are they really exempt from minimum wage? It's going to be our burden as the employer to prove that that exemption was appropriate. Now, keep in mind that simply labeling an employee as exempt isn't going to cut it, unfortunately, even if the employee agrees, right? So even if you and the employee both agree, like, yep, you're going to get a salary, you're not going to get any overtime, you'll be exempt from the FLSA, that DOL doesn't care, judge isn't going to care. We really have to do the analysis and see if the exemption is appropriate. Okay. So how do we get to an FLSA exemption? You can see on the slide here, there are two different tests that need to be met. The first one is the salary basis test. And the second one is what's called a duties test. Okay, there are no changes being proposed to the duties test. Okay, so keep that in mind. The duties test, at least right now, is remaining the same. Where we see the anticipated change is where you see that highlighting on the slide in the amount of money that must be paid as a salary to the employee per week. So remember, both the salary basis test and the duties test have to be satisfied in order to properly classify someone as FLSA exempt and therefore not have to pay overtime and not worry about the minimum wage rules. So I'm going to focus in for a moment on this salary basis test. Well, under this test, what we look at is, first of all, whether the employee is paid on a salary basis. And then secondly, we look at the amount of pay. What does it mean to be paid on a salary basis? Here's what it means. First of all, they must regularly receive a predetermined amount on a weekly, bi-weekly, monthly basis. And they've got to receive that full salary for any week in which some work is performed. So basically that means, we're not docking their pay because of some quality issues. We're not docking their pay because they had to leave early for the doctor. That's the kind of treatment that we see for an hourly employee, someone who is not salaried, where they would earn a little bit less if they work a little bit less. Okay, you can't have that if someone is FLSA exempt. So that's the first issue, is we need to make sure we're paying them on a salary basis. They're getting their full weekly wage for any week in which they do any work. And then the second thing is we need to make sure that the rate of pay is high enough. And this is where we see the proposed rule change. So right now, the rate of pay must be at least $684 per week. And so I'll talk a little in a moment about how that rate has changed over the years. We'll talk briefly about a proposed change from 2016 during the Obama administration that was actually struck down in the courts. But this is where we are right now, the $684 per week. Okay, so the second piece of the FLSA exemption is the duties test. So some of you may already be familiar with this, but I'm just going to kind of breeze through it briefly here so you have a full understanding of what it means to be FLSA exempt. Now, under the duties test, you can satisfy it by meeting either the executive criteria, the administrative criteria, or the professional criteria. So there are 3 different ways here to satisfy the duties test. And you can see a description of those various ways on the slide here. So executive, obviously, Their primary duty is management of the business or a certain subdivision of the business. An executive must regularly direct the work of at least 2 other full-time employees. And then an executive has to either have the authority to hire and fire, or the executive's input on hiring and firing decisions are given particular weight. That's the executive test. Administrative is where the employee's primary duty is performance of office or non-manual work related to the management of the business. So not production work, but something related to management of the business. And then also the administrative employee needs to exercise discretion and independent judgment on significant matters. So they need to be able to make decisions about how a budget will be allocated, for instance, or how a certain program will proceed. The third is the professional exemption. This is for what's called learned or creative professionals. It includes teachers, lawyers, physicians, anyone whose work requires kind of an advanced degree or particular originality or talent in an artistic field. Okay, so you can see here that the Department of Labor is really trying to focus in on people who have authority, decision-making power in the workplace, who maybe are supervisors, or people who are professionals in the workplace with some kind of advanced degree. So we look at this duties test, we look at the salary basis and the salary level. And by analyzing both of them, we're able to determine whether or not a particular employee may be properly classified as FLSA exempt. Now, I'm going to confuse things just a little bit. And it's not my fault, it's the Department of Labor. They make it even more confusing. But there are some specialized exemptions, and I just want to mention them to you because some of them might apply in your workplaces. There is a special exemption for computer professionals. So computer programmers, software engineers, they have their own rate of pay that applies in that situation. They kind of have their own analysis. Highly compensated employees. This is another one where, as you can see by my highlighting, there is a proposed change. So for highly compensated employees, the duties test is easier to meet. That's really what you need to know, is that if we have somebody who is making, who's meeting this highly compensated employee threshold, it's going to be easier to meet the duties test because they just have to perform one of those duties that I mentioned earlier. Okay, and again, that highly compensated employee sometimes is called the HCE exemption. That's another one that where we are seeing a proposed change. Okay, outside sales employees, they also have their own test. So folks whose primary duty is making sales or obtaining orders for services outside the workplace. Working from home does not count. I'm talking about people who are going to customer businesses as their primary duty, who are doing outside sales. Those folks also may be exempt from the FLSA's minimum wage and overtime rules. There's even more that you can see on the side of my slide here. Certain seasonal employees, commissioned retail sales folks, they can be exempt from overtime pay only, not from the minimum wage. There is also a Motor Carrier Act exemption that's going to apply to folks who are doing long haul driving. Motion picture industry, you can see a few more there. But really our main exemption that will apply to most employers, that most employers will be using to analyze their workforce, is the one I talked about a moment ago, where we have that salary basis test, we have the salary threshold test, and we've got the duties test. Okay, so as I shared a moment ago, the Biden administration, Department of Labor, is proposing a change to those salary levels that we have to meet. They are proposing that change both with the standard exemption and with the highly compensated employee exemption. And you might be wondering to yourself, why in the world, why is the Department of Labor doing this to us, right? Why is this happening? And really what it comes down to is the Biden administration's efforts to just put more wages into people's pockets. Partly, this is because efforts to raise the federal minimum wage have kind of stalled out. And so this is an alternative way for them to return some, put some additional pay into workers' pockets. The Department of Labor, in their press releases about this change, anticipates that these new salary thresholds will extend overtime protections to 3.6 million salaried workers. That is a huge number of people, okay? So we'll talk in a moment about what the new proposed levels actually are, but just flagging for you now, the Department of Labor anticipates that this will be affecting many, many people, many, many employers. Some of you might remember that some of you actually might be like having deja vu right now because you may have attended Grand Rapids Chamber presentation in 2016, sharing very similar information. And that is because during the Obama administration, the Department of Labor issued a new final rule that would have significantly increased these same salary thresholds. Okay, those changes were scheduled to take effect December 1 of 2016. It would have raised the salary requirement to $913 per week, or about $47,000 annually. That effort was blocked in the federal courts. And then it was ultimately rescinded by the Department of Labor. So that effort in 2016 never went into effect, but we certainly heard a lot about it. I think there was a lot of confusion at the time on the part of some employees who were trying to figure out what was going on. Certainly there was confusion and apprehension among employers about what was going on. I just want to show you kind of where we've been with this salary level threshold. So in 2004, it was raised to $455 per week. And the highly compensated employee threshold was $100,000, okay? You can see on the slide there in 2016, that was the Obama administration, Department of Labor, that was their effort to increase the level. It was a really significant proposed increase, up to $913 per week. That was ultimately rescinded. So that was not successful. It was blocked in the federal courts, ultimately withdrawn. But then in 2019, the Department of Labor did successfully raise the level of this salary threshold, raised it to the number that we have right now, $684 per week, about $35,500 per year. In order to meet this salary threshold, to meet our salary basis test, in order to get our FLSA exemption, so that an employee is not subject to overtime and minimum wage rules. Okay. Here you can see in the last column is what has been proposed. In 2024, the Biden administration's Department of Labor has proposed a new salary threshold of $1,059 per week, about $55,000 a year, and then also proposed elevating the highly compensated employee threshold to about $144,000 a year. You see my asterisk there. And what's interesting about this proposal, and was actually included in the 2016 proposal as well, but what we see in this proposal is a provision for automatic updates every 3 years. So we'll talk about that in a moment, what that would look like. But this is kind of an overview of where we have been with this salary level. Just a quick timeline for you of this 2024 rulemaking effort by the Department of Labor. So back in August of 2023, we learned that they would do this notice of proposed rulemaking. They issue a proposed rule. There's some public comment period. Public comment period closes. In December, the Department of Labor publishes its annual agenda, regulatory agenda. And in that document is where they identified April of 2024 as their target for publication of this new rule. Just earlier this month, the Department of Labor submitted its final rule to the Office of Management and Budget, okay, which has to do a review of it before it is published in the Federal Register. So let's take a closer look at what is included in this new rule. Well, like I said, we would increase the minimum salary threshold for those executive, administrative, and professional exemptions to $1,059 per week. That means if you do not pay an employee at least $1,059 per week as their salary, they will not meet the that exemption test. Now, if they're a computer professional, if you happen to work in the motion picture industry, if they're an outside sales rep, they might fit into some other tests, so be aware of that. But the general standard test that applies to most workers is going to be pegged at $1,059 per week. Second, this rule would increase the highly compensated employee exemption to $143,988 per year. As I said, there would be automatic updates to these thresholds every 3 years. This rule also eliminates some special thresholds for U.S. territories like Puerto Rico and Guam. It kept the special threshold level for American Samoa, just in case anybody has any workers in any of those territories. And then adds a special new salary level for the motion picture industry. So that's kind of the heart of this new rule. Some of you are probably wondering, Ashley, where did the Department of Labor get these numbers, right? Like, are they just like pulling them out of thin air? Like, here's a good number for a salaried employee. Well, no, they have not just pulled them out of thin air. What they are proposing is to set that salary threshold number at the 35th percentile of weekly earnings for full-time salaried workers in whatever is the lowest wage census region in the United States. So as you might already know, the US Census Bureau divides our country up into regions. Currently, the region with the lowest wages is the South. And so the DOL is proposing to peg the salary threshold to the 35th percentile of earnings for salaried workers in that lowest region. So when they looked at the 2022 census data, the Department of Labor found that this 35th percentile was equal to $1,059 per week. And so that's where they got their number. Similarly, the highly compensated employee exemption is tied to the 85th percentile. They tie it to the 85th percentile of full-time salaried workers nationally. So when it comes to the highly compensated employee exemption, they're not looking at what region has the lowest rate of pay. Okay, so once this final rule is published, likely in April, when will it go into effect? Well, we're anticipating that it will go into effect 60 to 90 days after publication, but we will not know for certain until we actually see the final rule, until it is actually published, okay? But that's kind of what we anticipate. I want to say just something else about these automatic updates. So the DOL is proposing that this salary threshold should be updated automatically every 3 years, right? So we don't go through this period where like it was updated in 2004 and then, you know, more than a decade goes by and it's a huge jump. So the DOL is saying, let's update it every 3 years and we will adjust it to remain at that 35th percentile of weekly earnings in whatever the lowest wage region is. Currently, it's the South. That could change. Similarly, the highly compensated employee exemption would also remain at that 85th percentile. So the Department of Labor every 3 years would do this analysis using census data and then would publish an updated salary level. They say they will publish it at least 150 days before the date that it is updated. So it would give folks a little bit of time to budget, to prepare. So that's what is being proposed. Okay. If you are looking for more guidance about these changes, the Department of Labor has published some additional guidance on their website, including a cute little video that you can see at the bottom there, where you can have cartoon people explain to you the FLSA exemption standard. They also have published a really comprehensive FAQ. You can see the website there. I'm sure you could also find it by Googling the Department of Labor FAQ, you know, salary exemption. So just wanted to make everyone aware that those resources are out there if you would like additional information. Okay, so a lot of us are probably wondering, is this really going to happen, right? Like in 2016, we all thought this was going to happen and then it was blocked. Is there any chance that it'll get blocked again? Well, the answer is maybe. There is probably not going to be successful congressional action to block these changes. That being said, there is a representative who has introduced a bill in Congress that would prohibit the Department of Labor from making these changes. But overall, it's not likely that any kind of barrier will come from Congress. We do anticipate some litigation challenges. And this is what happened again in 2016. There were some court cases challenging both the Department of Labor's authority to promulgate these rules and also the content of the rule itself. And as some of you may have already heard, there is a lot of federal court scrutiny of administrative agencies and their rules right now, including at the Supreme Court. So the Supreme Court is currently in session, as we know, and this year, the Supreme Court has already heard 2 arguments challenging some feature of these administrative agencies and the rules that they create. So the Supreme Court has heard an argument challenging deference to administrative rulemaking. And then they have also heard an argument challenging agencies' enforcement power. So it's possible that in this environment where there is a lot of scrutiny of federal agencies and the rules that they issue, that there could be a successful litigation challenge to this new rule. We just will have to wait and see. We really don't know. So practically, what should you be doing as employers to prepare? Well, the first thing is to remain alert to publication of the final rule, which we are anticipating in April 2024. Be aware that the final rule could be different slightly from the proposed rule that I've just spent the last half hour talking about, right? Like, we have not seen the final rule yet. There is a chance that there could be some differences in the final rule that comes out. Interestingly, there was a footnote in the text of the proposed rule saying, you know, yeah, we're going to target it at like $55,000 a year, but just FYI, the salary figure could be closer to $60,000. That was just a footnote in the proposed rule that, like, yeah, we're proposing it, you know, at this $1,059 per week, but it might be a little higher than that. So just be aware that when we get the final rule, there might be some slight changes. I don't anticipate significant changes, but we need to be aware that there could be some small changes. Plan and budget as though the final rule will go into effect and legal challenges won't be successful, right? That's the best way to secure your organization in case these rules go into effect and legal challenges aren't successful at blocking them. I recommend that you perform an analysis of your current workforce. And I will talk about that analysis and what it looks like in just a moment on the next slide. But the last thing I want to say here is we need to be really proactive about our communications to employees, right? Because once this final rule is published, there will likely be some news coverage of it, right? Both business news and, you know, regular news that people consume. People will probably be hearing different things from family and friends. It's going to sound like maybe everybody's getting a raise, but I'm not really sure, like, what's happening. So I would really encourage you to be proactive and put together some talking points when employees have questions about this. I would, you know, to the extent you have anyone at your organization who's in charge of internal communications, make them aware of this so that they know this could be coming up.
Didn't she tell you that she did? Did she say an email?
So she, as far as I know, I wasn't in like the initial conversations.
Okay, I'm just going to keep going. That the analysis that I want to end with is my recommendation.
Ashley, I'm going to have you pause real quick. If your mic is open, we're getting some feedback. So if you can mute your mic, please. Thank you.
Thank you. Okay, so in the previous slide, as I was kind of talking through how to prepare, one of my recommendations was that we perform an analysis of our current workforce, right? So what am I supposed to do, right? Like, how do I perform this analysis? And that's what we have here on this slide. So the first thing you're going to want to do is identify all positions in your organization that are currently classified as FLSA exempt, meaning that they're being paid a salary, they're not eligible for overtime, you're not looking at minimum wage rules with them, you're classifying them as exempt from those rules. Then we're going to take a look and say, are these people properly classified under the current standards? So if we were to just look at that 684 a week, are we meeting, you know, the current standards? Because if you're not, that's something that you want to be aware of. Okay, so you're going to look at the salary basis, you're going to look at the salary level, and you're going to look at the duties to evaluate whether or not these folks are properly classified under the current standard. Then you want to take a look at whether or not these people would remain properly classified under the new standard. So again, we'll be looking at the salary basis, looking at the salary level, and then looking at the duties. As a reminder, there are no proposed changes to the duties test. It's just that salary level that we're looking at. So if you find that you have an exempt employee who is earning less than $1,059 per week, you have a couple options. First, you could raise that person's salary to at least $1,059 per week and maintain their FLSA exemption. Or you could reclassify them as non-exempt, which means you would just need to start tracking their hours, and you would have to pay overtime for all hours over 40 in a work week. Just as a reminder, overtime is 1.5 times their hourly regular rate of pay. When we calculate that regular rate of pay, that's a whole nother presentation about what we include in that regular rate, whether or not we need to include bonuses and commissions, that kind of thing. But really, if you find someone who's currently classified as exempt, who would not be classified properly if this rule were to go into effect, those are the two options that you really have. You can raise their salary, or you can start treating them as non-exempt. You'll also, if you have people that you start classifying as non-exempt, you're going to want to think through ways to manage or limit overtime in your workplace, right? So maybe that means taking a closer look at some scheduling. Maybe that means hiring another person to avoid overtime for one of your existing employees. You also want to be really aware of folks working from home remotely. One thing that we often see with non-exempt employees, so people who are eligible for overtime, right, is they'll get their email on their phone and they'll spend 15 minutes sitting on the couch in the evening, like replying to emails on their phone. For an exempt employee, right, that's no problem at all, like not a big deal, great. For a non-exempt employee, we need to track those hours. So we need that employee to be reporting that they did that 15 minutes of email from their couch on their phone. We need them to report that to us so we can pay them for it, and so that we can count it when we're evaluating whether or not they are owed any overtime that week. So we want to be really mindful about either taking email off of non-exempt employees' phones. That's something that I've seen some employers do. They just are like, you know what, you don't have your email on your phone anymore because it's too hard for us to track when you're working and when you're not. Or, you know, we we need to just be really clear with them that you're only authorized to work these hours. So that's it from me. I hopefully have left some time. I know that we have some questions. I, of course, will make myself available if anybody wants to reach out after the presentation. My contact information is there on the slide, so please feel free to reach out to me, and I'm happy to continue the conversation. But I think now we want to turn to some questions. Is that right, Jackie?
That's correct. Thank you, Ashley, for breaking down that complex information. I've had several questions come in. We'll start with the first one from Janice from Express Pros. She asks, how does this impact employees that make a base plus bonus?
Right. Yeah, that's a great question. So the FLSA allows employers to count some of a bonus toward that salary threshold number. So yes, you can count some of it. You're going to need to take a close look at that rule. I think it's around 10% of the salary level can come from a bonus like that. But you absolutely are allowed to count part of the bonus. It will also depend in part on whether or not it's a discretionary or non-discretionary bonus, whether or not it's something that's just kind of part of a standard profit sharing, or if it's something that the employee is earning every year through performance-based metrics. Great question.
Our next question comes from Jacqueline at Flat River Group. She asks, how long will employers have to get in compliance with the final rule once issued?
Yep, we're anticipating about 60 to 90 days. So once the final rule is published in the Federal Register, we will see, it will say in the final rule, this is the effective date. And we're anticipating that it will be 60 to 90 days after the publication. So it could be a little bit longer. They might give folks more time. We just won't know until we see the final rule as it's published.
Good. Our next question comes from Kate. She asks, if they are salary plus commission, does monthly commission count toward the rate amount?
Great question. It depends on the way that the commission is structured. So it might. There are some employees for whom you can count the commission. Absolutely. We also have that outside sales exemption that I mentioned earlier in the presentation. That's one of the special exemptions that we have. There's also a retail sales exemption that only exempts you from overtime, not from the minimum wage, but that's another specialized exemption that you can look at if you have a retail sales environment.
Good. Jennifer asks, does that include part-time employees in that salary amount, or how does that work with part-time employees?
Great question. So no, that salary level is for full-time employees. If you have someone who is salaried at a part-time level, right? So it's prorated. So you would want to make sure that the wage they are making, if they were full-time, would meet that $1,059 threshold.
Barbara asks, is comp time a valid trade for overtime pay?
It depends on this. That's another good question. It depends on the situation. So generally, no. Generally, if the comp time is taking place in a different work week. So under the FLSA, every employer needs to identify a work week. So whether it's midnight on Sunday, through the next 7 days, or if it starts on Monday morning, whatever it is, you need to identify a set 7 days that is your work week. And any hours worked over 40 in that 7-day period will, you have to be paid time and a half. Now, if the comp time occurs within that work week, right? Like if they spend some time not working, then yeah, we'll probably reduce, reduce that overall 40 number. But if the comp time is being taken in a different work week, it won't count.
Okay. John asks, if a company changes the employee's status from salaried to salaried eligible for overtime, does that solve the issue?
I guess it could, as long as you are tracking the employee's hours, right? So you know exactly when they hit that 40-hour per week. And then making sure that the overtime, you would have to look at what's the overtime rate that they're being paid, right? Because it needs to be 1.5 times their regular rate of pay. So I think it would come down, you would need to do some math to make sure that whatever, you have someone who's like basically getting a salary, but they're actually non-exempt, right? So they're getting overtime. You're tracking their hours. Is that overtime rate 1.5 times whatever their regular rate of pay is during the week? And you would have to do that regular rate of pay calculation, which is a bit complicated. So, you're going to want to work with your HR team, with your, perhaps with your labor and employment attorney, to make sure you're calculating that regular rate of pay correctly so that you're paying the right amount of overtime.
All right, we have just a couple more questions. Adventure Credit Union asks, you mentioned something about if they pass a different test, the salary test may not apply. So for example, if an employee is considered a computer professional, do they still meet, or do they still need to meet the salary test?
Yeah, so the computer professional test, here, I will go back to it a moment. Yeah, there we are. Okay. So they need to either, you can see it on the slide here, excuse me, they need to either satisfy the salary basis test or be paid on an hourly basis at $27.63 an hour or more. So they kind of have their own special wage test for them. You can always satisfy it by satisfying that salary basis test that we have been talking about, or you can satisfy it with this particular hourly rate. And then of course they need to satisfy the duties test as well.
Elizabeth asks, can you please explain exemptions for nonprofit organizations?
Yeah, so this Department of Labor rule does cover nonprofit organizations. Now, the FLSA in general covers nonprofit organizations. If the, so there are two types of coverage. There's enterprise coverage, which means your organization does $500,000 or more in business per year. There is also individual coverage, which means that the particular employee that is in question is engaging in interstate commerce somehow. So that is a very easy test to meet for the government, for, when the government is trying to bring these protections, these overtime protections, to as many workers as possible, right? So their goal is to construe this law as broad, as covering as many workplaces as possible. That does include nonprofit organizations. There is a carve out for if your nonprofit organization is spending, let's say, 30% of its money, of an employee's time is spent doing like explicitly religious work. There is a way that you can analyze that, and you may be able to carve some of that out when you're looking at coverage. You can see actually the FAQ that I mentioned earlier. See if I can advance to it. Oh, I don't know if I can find it, but the FAQ that I mentioned does have some, a question and answer about nonprofit organizations, so that you'll be able to get more information there. And of course, I'm happy to answer follow-up questions as well.
Ashley, Beth asks, would customer service specialists or tech support meet the duties test under administrative, in your opinion?
You know, it's really a case-by-case analysis. So we would need to look at the job description, okay? We would need to look at the what the person is doing. Typically, if you're trying to fit someone into the administrative exemption, the trickiest piece is always that independent judgment, right? So are they exercising discretion and independent judgment? For a computer tech support analyst, right, we would really have to look at, are they empowered to make decisions, right? Or are they kind of more following a formula or following guidance from a manager? So it's really an individualized analysis that looks both at the job description and what is actually happening on the ground and how much decision-making authority the person has, at least with regard to the administrative exemption.
Okay, can you explain the commissioned employee exemption?
So, probably not in the amount of time we have left. But there are, as I said, special rules for how you can count commissions into a person's salary level to meet that threshold. There is, again, the outside sales employee exemption. There is a separate exemption for commissioned retail sales employees who are in a commissioned environment. And then there is a general Department of Labor rule that you can allocate a certain percentage of an employee's commission or bonus to that salary level.
And we've got time for one last question.
Yeah.
Is it suggested that when changing classification, is it recommended to change the whole category so that the group
Yes.
is the same exemption status, or should it be
Yes.
done piecemeal?
Great question. So one of the things that the Department of Labor will look at, or a judge would look at, is whether or not this person is, do we have other people in the organization doing the same work who are not exempt, but you're trying to treat this person over here as exempt. So you really do want to look at classifications of employees to the extent they have the same duties, right? So if you have someone who is elevated a bit, who is a supervisor, or who has more decision-making authority in the workplace, you can certainly treat that person differently, right? Because they might meet one of the duties tests that other folks wouldn't meet. But by and large, I would absolutely recommend looking at classes of employees so that you are treating people equally. That's also a way that you can avoid a discrimination claim down the road, right? If we, as one of our goals as employers is to make sure that we are treating groups of people the same. And so we want to avoid a situation where someone might say, well, you made me exempt and denied me overtime because of who I am as a person, because of my religion or because of my race or my gender. We want to avoid any situations like that. So that's another reason why it's good to look at job classifications together.
Great, thank you. Ashley, if you could unshare your screen real quick for me.
Absolutely, yes.
Share my screen. All right, Ashley, I just want to thank you so much for joining us and helping us prepare for those proposed changes. This is important to our members, so I'm glad you were here to guide us through it.
Absolutely. Thank you for having me.
I'd also like to thank our government affairs sponsors, Amway, Blue Cross and Blue Shield of Michigan, Comcast, and Roman Manufacturing. I'd also like to remind you that if you haven't registered yet for the Grand Rapids Policy Conference, there's still time to do so. You're not going to want to miss out on it. Have a great day, everyone. Thank you so much for joining us.